Hello everyone, and welcome to the Adams & Reese AR/HR Summit. I'm Bradley Byrne. I'm special counsel to the firm, and I'm joined today by Michael Berson, who is a partner in the firm. Both of us, work in the Mobile office. We're going to talk today about a very important topic, and that is some of the changes that have occurred in labor and employment law as a result of the new administration, the Biden administration. Michael spent several years on the Hill working on the U.S. Senate side. I spent several years as a member of the House of Representatives, a member of the Education and Labor Committee, and the chair of the Workforce Protection Subcommittee. So we have a little background in what we're talking about. Now, just a few housekeeping details before we get started. We'd love to hear from you today. If you have any questions during the presentation, please type them into the question box in your control panel. Only our presenters will see the questions submitted, and we'll have time to address them at the end or by email following the presentation. Also, near the end of the program, you'll see a badge on your screen, and you can download your continuing education certificates at that time. Now let's get started. A lot of new changes in labor and employment law with the Biden administration. Michael and I are going to focus on two today, both of them extremely important. The first one is on worker classification. So Michael, why don't you get us started on the issues there?
Sure. The classification of workers as employees rather than independent contractors is going to be a major issue under the Biden administration. It's critical for a number of purposes, mostly from federal and state labor law and employment law standpoints. It impacts all of them. Generally speaking, the rights and protections afforded by these laws are available only to employees and not to independent contractors. And across the country, courts and administrative bodies have used various tests to make worker classification determinations in light of some of the more vague and circular definitions that have been adopted for the term employee in some labor and employment laws. Bradley, if you don't mind, talk a little bit about kind of the broader interpretation of employee status and the impact that has.
Well, the key thing here is that if we used to know that if you had direct control over your person, your employee, that's your employee. And if you didn't have direct control over them, they weren't your employee, they were an independent contractor. Then in the Obama administration, they broadened the definition and made it much more nebulous so that someone that you thought was your independent contractor was actually determined to be your employee. So let me give you an absurd example. You contract with a business to come and take care of the grounds of your business, mow the grass, do whatever. You don't think of the person that actually comes there to do that work as your employee. They work for your independent contractor. Under certain definitions, that person, because you have some indirect control over what they do, could become your employee as well as employee of your contractor. That's very problematic. Now, let me give you a more precise area where this gets to be a problem. This gets to be a problem when we start talking about what's called the joint employer doctrine, and particularly for franchises. Think about Big McDonald's and a McDonald's franchisee. Well, Big McDonald's doesn't hire the people that work in the individual McDonald's restaurants. The franchisee does. But if you broaden that definition out, that person that works in the McDonald's restaurant can be not only the employee of the franchisee, but also the employee of big corporate McDonald's. This totally wrecks the franchise paradigm. So these definitions and how we're going to handle it are critically important to every business in America. And Maki, you might want to get into a few more details about that.
Absolutely. And I think one person who is going to have a huge impact on what Bradley was just talking about is President Biden's pick to run the Labor Department's Wage and Hour Division, David Weil. He has faced some fierce opposition from a number of business groups. In mid to early July, the Senate Help Committee held a nomination hearing for him. So David Weil, just to give you a little background on him, he held the wage division post in the Obama administration from 2014 to 2017. During his tenure there, Weil pushed really hard to classify independent contractors as employees, and in doing so also tended to criticize a lot of the gig companies, which we'll talk about a little bit later in the presentation, and franchises for relying on contractors. When he was at the Department of Labor, he also had a number of different things that he did, one of which was the extended mandatory overtime pay to more than 4 million workers, a measure that was ultimately blocked by a federal judge following a lawsuit by some of the same business groups that are now opposing Weil's nomination. So when the Trump administration came in, they replaced a lot of Weil's rules with more business-friendly policies. But since then, the Biden administration has kind of come in and rescinded a lot of those measures. And Bradley, if you have time, talk to us a little bit about, some more about what DOL is taking and the approach, that they're taking under the new Biden administration and the withdrawal of Trump's independent contractor rule.
Well, Weil is trying to not just go back to where things were at the end of the Obama administration, he's trying to extend them even further. So they're trying to greatly expand what the definition of an employee would be. Who can be your employee? Who can be that employee's employer? The joint employer doctrine is one of the key issues there. So the Obama administration expanded it so far that many employers, many businesses didn't know if they were an employer of a given person or not. And so when the Trump administration came in, I was asked to be the sponsor of a bill that would have made it very clear, very concrete, who was going to be the employer of this employee and who would not be. We weren't able to get that. We got through the House. We weren't able to get it through the Senate. But the Trump administration took the definition in that bill and actually put it into law as part of their regulatory effort. Well, now Weil's going to take that back and then some. So the concern here is that you've got to know, as a business owner, as somebody that has responsibilities that somebody's your employee, who is it that is my employee in this environment? Who do I owe those responsibilities to? Well, the new test, if it goes back as we believe it will to the Obama era and then some, the new test is going to make a lot of people who you don't think are your employees right now, your employees to whom you will owe legal responsibility. And Michael, that's very problematic in a lot of cases.
I couldn't agree with you more. It is, the withdrawal of that Trump administration independent contractor rule, which was originally scheduled to go in effect on March 8th of 2021, it's going to have a major impact moving forward. And, several things that we're watching are, and Bradley, I'll let you touch on this and kind of give a brief overview, or some of the cases, the worker classifications that we're watching, and the impacts that some of these court decisions are going to have moving forward.
Well, the Janie King case in Oklahoma, Western District of Oklahoma, is another case about how you classify an employee. In this case, it's in a janitorial company. And what they're trying to say is that the cleaning company misclassified its employees as independent franchise owners rather than employees, and they were doing so with the purpose to avoid federal obligation. Janie King claims that it sold cleaning company franchises to individuals. So the Department of Labor is trying to make the case that Janie King controlled all aspects of those businesses, and therefore the franchisees should be classified as employees. So this is one of those cases that the courts are going to tell us. Now that's a key point here. Even if the Department of Labor says this person's your employee, it's really ultimately up to the courts. And so some of these things are going to have to be taken to court for us to get a good, clear ruling. And I'm concerned there, Michael, because I'm concerned about how much time and money that's going to take. Even if an employer wins, they're having to spend all this time and money to get to that point. So it's important, I think, that we fight back against these misclassifications by the broader definition, first and foremost at the Department of Labor level, but we may find ourselves having to go to court as well. Either way, I think it's important for employers around the nation to stay on top of this as things evolve over the next 3.5 years.
I agree, absolutely. There are a number of other cases. The Diligent Delivery Systems case out of Arizona, the Phoenix Division, the Successful Aging Care case out of the Eastern District of Pennsylvania. All these cases are, they were brought by, for example, the Diligent Delivery Systems Department of Labor brought a case contending that some of their drivers are actually owed $30 million roughly in unpaid minimum wage and overtime. And the Successful Aging Care case, the Department of Labor is alleging these home health aides are owed similarly back pay and damages because they were misclassified. So these cases are going to have a tremendous impact, and Bradley's absolutely right. The cost, the time and money that's going to go into litigating all these is going to be tremendous.
Yeah, that's true on the change in the joint employer rule, which I was talking about earlier. I'm really concerned about what they're going to do there. We thought we had all that straightened out, clear. Everybody was happy. Everybody understood where they had obligations, where they didn't. Now we're unwinding all that. And I guess the main point there is this. We know that these rules are going to evolve over the next 3.5 years. We know that they're going to be court cases. And you just can't go by what you've done in the past because of the changes that are going on here. Everybody, every business in this country needs to sit down with whoever they rely upon to provide them labor law advice to make sure that they're doing everything they can to, first of all, understand where they are and how these things are changing, but also what they can do to make sure they're in compliance. And if somebody comes after the Department of Labor, or somebody comes after them, what they can best do to posture themselves to be able to defend themselves. We have lawyers at Adams and Reese and every part of our footprint throughout the Southeast who have that expertise, who can sit down and do that with you. Or if for some reason you get into a problem with the Department of Labor, we have lawyers that know how to handle that for you. So first and foremost, stop, look at your situation, talk to a labor lawyer, and make sure that you know what you need to know to be clear about where you are with a particular person that may be doing work for you that you don't think is an employee, or to make sure that you're in the best posture possible to defend yourself against the Department of Labor action or some other regulatory action.
Bradley, I think you're absolutely right, and engaging with your counsel to address some of those issues you mentioned are critical. Touching briefly on the current state of non-compete agreements. If you have time, kind of go through some of give an update exactly on where we are with non-compete agreements today, what's kind of transpired recently, and what maybe some of the growing trends are.
So up until just recently, we always thought of the law that governs non-compete agreements to be something that's set at the state level, not at the federal level. So up until recently, there hasn't been much of a discussion about non-competes at the federal level. There have been some general things, but not really no action that would get us to a point where the federal government is actually truly contemplating doing something about this. In general, the courts around the country have not been that favorable to non-compete agreements, particularly when you're looking at somebody that's not at a high level or high expertise level, somebody that's more of a production employee. They're just favoring them there. They always want to try to narrow the geographic scope of the non-compete, narrow the time frame for the non-compete. Well, a few weeks ago, the president issued an executive order, and under that executive order, he directed the Federal Trade Commission to consider adopting a rule that would govern or regulate non-competes under certain circumstances. Now, it's very general direction under executive order. It doesn't obligate the Federal Trade Commission to do anything other than consider it. But because of the concern that's been going around the country about this for some time, I think it's likely that we're going to get some sort of regulation from the FTC. I don't think it will apply to employees at the top end. I think it's more likely to apply to employees at the other end. And the scope of it's going to be a big deal, et cetera. There's a real question whether the Federal Trade Commission has the statutory authority to issue anything with regard to non-competes. And I think we'll see a legal fight about whether they have that statutory authority. But assuming they do, and assuming they actually utilize that authority, Michael, I think we're going to see some interesting regulation, whatever, coming from the FTC as to whether those people that aren't at the very tip top of your organization can be subject to a non-compete, or if they can, under what very strict circumstances you'll have to operate.
I agree, and I know in the past there has been some efforts at the federal level to regulate non-compete agreements. I know there have been a number of bills introduced to either ban or significantly curtail non-compete agreements in the employment setting. They have generally not gone anywhere. So this is really interesting development. I believe in early January of 2020, the FTC started pulling together, I think, a working group to look at whether or not they had the authority, as Bradley was just talking about, to regulate non-compete agreements. And then the most recent executive order from President Biden kind of took another step in that direction, encouraging the FTC to go ahead and examine whether or not they have the authority to curtail some of the unfair, as they've said, unfair uses of non-compete agreements. And Bradley's absolutely right. It'll be interesting to see where they land on some of this and the classifications of employees. Some more of those lower wage employees are going to see some differences when we see regulations from the federal government on how these non-compete are going to be implemented.
Yeah, Michael, those workshops started under the Trump administration, okay? So we need to understand this isn't just something that liberal Democrats are about. There was concern about this before. I think where we're headed here is this. If you can show that there is a real need for the non-compete, for example, the employee you're trying to apply that non-compete to has some specialized knowledge, perhaps about your customer base, perhaps about your processes, etc. If you can demonstrate that need, then I think you're going to be able to keep your non-competes. But if you can't, if you just have sort of a blanket non-compete and you can't show, well, I've got to have a non-compete for this employee because if they leave and go somewhere else, they're going to take this specialized knowledge or skill or whatever that they got here and use it against me over there. I mean, you got to have something pretty specific. So I think where we're probably going here is some sort of a test, and how they word it's going to be very important. But a test that would say, if this person has this sort of specialized knowledge or experience or understands your customer list or whatever it is, then we're going to allow you to have a non-compete. But if this is a production employee and they just got an extra $1 or $2 an hour and they've gone across the street to your competitor, you have a hard time, I think, keeping that non-compete agreement going, whether it's under the FTC rule or perhaps if you get sued in state court over that. So I think this is a time, not just because of the Biden administration, this is a time where we all need to be rethinking, all right, do we really need a non-compete for this particular employee or this particular group of employees? Or should we be a lot more judicious, be very, very careful about who we are actually putting non-compete agreements on? Because we're in a period of time, I think, where we're making a big transition, and it's time for all of us to take another look at that.
Absolutely, Brad. And the process that you've been talking about here with the new administration and even going back to the Trump administration, it's going to require multiple steps to implement any regulation should the FTC act. It's going to include everything from publishing kind of a detailed and specific kind of notice of proposed rulemaking to drafting text to the rule, engaging the public. This is a years-long process, but it's something that has gained significant traction, more so than it has under previous administrations. So the language in how, if the FTC acts, the language in how they regulate as what they determine to be the unfair use of non-compete clauses and other restrictive covenants, it's going to be very, very interesting to how they define unfair use. And the ultimate scope of this rulemaking it's still kind of up in the air, but it's definitely something that needs to be on your radar and is certainly on our radar.
Yeah, I think that we are seeing a definite trend here, Michael, and I think we all need to be a lot more conscious about it. In the past, we just threw those things out there and didn't really think much of it. But that trend is showing us that we're going to have to all question the enforceability of our non-compete clauses. Are we going to end up in court, or are we going to end up with a regulatory action from the Federal Trade Commission? So I think we all need to be looking at that. Lawyers, business people, everybody needs to look at it. And be prepared for some significant action to occur here at the FTC level.
I agree, and going back to to seeing exactly what that FTC action looks like and what the requirements they're going to be placing on employers, whether or not they have to offer garden leave or requiring more rigorous other restrictions on the use of non-competes for low-wage workers and other categories, as Bradley just mentioned, or requiring greater transparency. It's something that's kind of to be seen, but it's they're going to be working on a draft text and draft regulations, and it's something we're very, very closely monitoring. Bradley, one of the big issues that we have seen and that has come up both under the previous administration and now the current administration is the impact on gig workers. And would love to hear a little bit about how the Biden administration's recent moves and possibly future moves would impact gig employers in this economy.
This is a major issue across the country. You know, Michael, they had that big referendum in California to try to pull back on some of the things the California state government was trying to do. I'll never forget, we had a hearing when I was on the Education and Labor Committee, and we had a guy there who was an Uber driver and a Lyft driver. And I asked him, do you consider yourself to be an employee or an independent contractor? And he said, neither, I'm a franchisee. And I said, well, I don't think you're that. But what that shows us is that a lot of these people that work in these gig jobs, they don't think either classification works for them. Now, what the Biden administration wants to do is to make every gig worker an employee. And if they can figure out a way to do that, whether it's using wage and hour law, National Labor Relations Board, whatever, they're going to try to do that. Because the more people that are employees, the more employers, more people that these people work for, they can regulate. And Michael, that's a key thing here. This is the most pro-labor, pro-union administration since Franklin Delano Roosevelt. And part of what's going on here is that they're very close to the big national unions. The big national unions want everybody to be an employee of at least one employer, if not multiple employers, because that gives them more targets for them to try to go and organize. I mean, that's a big part of what's going on here. So I think you can see a major effort here by the Biden administration as to any gig business to try to make the business an employer of somebody that gig business now believes is just an independent contractor. And Uber and Lyft are just two examples. There are dozens and dozens and dozens of examples we could talk about here. And so this issue is something that's going to have broader application than any of us could have seen. So once again, if you think somebody is your independent contractor and you're a gig business, they've got a real focus on you right now. And you may want to step back and say, is there something I need to be doing to make sure that they don't designate this independent contractor, gig independent contractor, to be my employee? And we have got lawyers and Adams and Reese throughout our footprint that can sit down with you, work through that with you, and put you in the best possible place you can be to make sure that you maintain your independence and their independence in your relationship.
Bradley, that is extremely important. And one thing that I would like for you to expand upon a little bit is in your time in Congress working on the PRO Act, or the Protecting the Right to Organize Act. And if you could give everybody a little background on that legislation and what you did working on that measure, it's I think it's definitely something we'll see what ends up happening under the current administration. But the amount of money I think that was poured into California to overturn a ballot measure out there that you just referenced to reclassify drivers as employees in that state, and the other potential legislation in addition to the PRO Act that may be coming forward. But if you can give folks a little bit of an overview of the PRO Act and kind of what happened and where it is now, I think that would be really beneficial.
So in the last Congress, you didn't have a Democratic president, but you had a Democratic House of Representatives. And the Democratic leadership in the House, beginning with Speaker Pelosi, brought this PRO Act to the Education and Labor Committee. And I was told that the PRO Act was actually written by the big national labor unions, particularly the AFL-CIO, and literally handed to Speaker Pelosi, and she in turn had it introduced and handed to the committee. And if you read the PRO Act and you know anything about what has been labor law in this country, The PRO Act completely rewrites it. It completely does away with what we've always thought was a more or less level playing field between labor and management, unions and businesses. It would do away with that. That's the last thing in the world the unions want, is a level playing field. They want a very unlevel playing field. And they think that this PRO Act will accomplish that. Well, they blew it through the House last Congress, but when it got over the Senate, Senator McConnell said no way, and it never came up. Well, it can't come up in the Senate even with the very slim Democratic majority they've got now, because it would take 60 votes to do it. And I don't think they're going to change the 60-vote rule. So, Michael, what they're trying to do is slide at least some of the provisions from the PRO Act into this big $3.5 trillion reconciliation bill. Remains to be seen whether they can pull that off and what provisions would be in there. The one provision I am hearing from the PRO Act that's most likely to be in there that'll pass the review from the parliamentarian in the Senate is giving the Department of Labor the authority to issue penalties. Right now, the Department of Labor can't issue penalties for a lot of these things. So what they're trying to do is to, I said the Department of Labor meant the National Labor Relations Board, they're trying to give the NLRB the ability to penalize employers that violate the National Labor Relations Act. Well, we've never had that before. There are a lot of other things in there. Their version of the joint employer rule, their version of the independent contractor rule. They're going to try to find a way to put all that stuff in that reconciliation bill so they don't need Republican votes. They don't need 60 votes. And if they're able to do that, then this stuff is not just a regulatory problem, it's a statutory problem, which means in the next administration we wouldn't be able to pull it back. So this PRO Act and any parts of it that they try to shove through as an independent piece of legislation or in the reconciliation bill, we're going to have to watch that very carefully. Michael, these are all just examples of the bigger thing. We're looking at an attempt, at least, to have a wholesale shift in labor and employment law in this country. And whether they're successful or not, we're all going to have to deal with it. And it's going to last for at least 3.5 years. And if President Biden gets reelected, 7.5 more years. So this is changing things for lawyers who practice in this area. But more importantly, it's changing things for businesses and employers around the country who haven't had to deal with a lot of this up until now. Well, everybody, we really appreciate your taking some time to participate with us today. We hope you've had some takeaways for your organization, and we hope you will join us for our remaining programming this week. There are a lot of important topics here in labor and employment law, a lot of important things, as we said, happening with the Biden administration. And a number of our partners and other special counsel are going to be providing you with, I think, some really good programming for you to look at, and hopefully it will be helpful to you in what you're trying to do. And always, 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 we are here for you. We know these are difficult issues. We know these are trying times for you to try to deal with all this. Let us help you. We have the expertise, the people to do that. Have a great day. Hope to see you again soon.